Hey, welcome to today's video. Today we're looking at what makes the DMCA controversial. I'm Rick Chapo with DMCAagentservice.com. So the DMCA and controversy, is there any? Yes, there is. The DMCA is unique in that there are three parties that are really affected by the section we're looking at, which are the safe harbor provisions in Section 512. And those would be the content creator, the internet service provider, which is typically the website or an app, and users. And so how do these three work together? Well, the DMCA Section 512 basically says that an internet service provider cannot be held liable for copyright infringement based on content uploaded by users. So let's take Facebook as an example. I have an account with Facebook. I see an article on the New York Times that I think is swell. I copy it and I post it to my Facebook page and say, hey, everybody read this. Okay, well, that's pretty much copyright infringement. There's no fair use defense to that. I have copied the content from the New York Times and have reposted it to Facebook without the permission of the New York Times. So in this situation, the New York Times is the content creator, I'm the user, and Facebook is the internet service provider. And under the DMCA, Facebook cannot be held liable for this. I can because I'm the user who posted it, but Facebook is immune. And so you could see how this might lead to problems, and it has. Over the last 21 years, the law has been in place. So let's look at why controversy follows this law from a creator perspective. And the problem is when you create content and publish it online, it will be copied and redistributed to other places without your permission. And the problem isn't so much that it's done one time, because in that situation, you can go identify what that site is or app is and submit a DMCA takedown notice and probably get it taken down. It's probably not going to be a big issue. But the problem is, the internet being what it is, your content is not copied once. It's copied 20 times or maybe hundreds of times. So let's look at an example how this might be really, really aggravating. Let's say you spend a bunch of time and money creating a course, and you sell it to a group of people. You put it online on your website. Literally within a day, somebody will have copied your entire course, and they will be republishing it on other sites and selling it, often for less than you're charging. And this is where the teeth gnashing comes in. It's obviously that's going to make you furious. And so you go out and you identify these sites and you submit DMCA takedown notices to them. And the sites say, oh, sorry about that. And they remove the course from their sites. Now, under the DMCA, the person who posted that content can be held liable for it, but the sites cannot. And so, what are your real remedies in that situation? Well, kind of have to grin and bear it. Except the next day you go to Google, you do a search for your course again, and you see now it's up on 20 new sites, 20 different sites. And you have to go and hunt down those sites and submit DMCA takedown notices. And as you can see, this becomes kind of a never-ending process. It starts taking up all your time, and it can often take a day or two for those sites to take down the content. And the course is being sold during that time, and you're not getting the money out of it. And your teeth are grinding. You're yelling at your significant other. And it drives you nuts. And so that's why content creators tend to hate it. Now, what about users? What about the user side? Well, if the content creators have problems with a volume of infringements that are out there, what do you think a lot of them have done? And the answer is they've purchased automated software that will go out and scan the web, much like a site like Copyscape does. It will go out and scan the web looking for certain parameters, certain characteristics, maybe keywords, maybe file names, things of that sort. And when it finds those, it makes an assumption that content is the content of the copyright holder, and it sends a DMCA takedown notice. Now, the problem in that situation is a lot of times the notices are being sent when they shouldn't be. So somebody can take your copyrighted content and use it for certain allowed purposes under copyright law. These are often called fair use. So, for instance, if I copy the first minute of a Game of Thrones episode in season 8, and I post it to my blog because I want to write an article about how much season 8 sucked, which it did, that's a fair use. It's a form of criticism. It's like a movie review. I can do that. We allow that in our society. Everybody knows it's not even controversial. It's not even a close question or anything of that sort. But automated software is going to have a problem differentiating that from somebody who's just copied an entire episode of Game of Thrones and posted it for free up on Reddit or something of that sort. And so in those situations, the software should not be issuing the takedown notice. We've even seen abusive situations where companies have released press releases. Microsoft did this. They released a press release about some product, and it triggered their automated software. And so the automated software started sending DMCA takedown notices to every site that had published Microsoft's press release. So Microsoft was, complaining that its own press release constitute copyright infringement. Obviously, it was a bit embarrassing, and they retracted all the notices and everything else. But you can see the problem. So the problem with all of this also is that it's a lot of people feel it's a chilling on free speech, because let's say that I went ahead with that Game of Thrones review. So I have a minute of the Game of Thrones video. I am completely legitimately using that content. There's not even a remote infringement claim there. I have every right to do that. I receive a takedown notice from HBO. Am I going to fight that? And the answer is maybe, but also maybe not, because I'm going to have to pay a lawyer to go out and fight it. I'm going to have to, I can serve what's called a counter notice. And then the company or the host, wherever I'm hosting my site, is just going to give that to HBO. But then if HBO has the right to go ahead and sue me. And so if they sue me, now I have to hire an attorney to defend me. I'm going to spend maybe $50,000, $70,000, $100,000 defending myself over this usage of this small amount of video. And if I win at the end, I win, but I don't get any money. So I've just blown $70,000 or $100,000 defending myself. And, it's a moral victory, basically. And I'm still out all that money. So a lot of people, even if they have a valid use, they're not going to contest a DMCA takedown notice. And so it has a chilling impact on free speech. So if you look at them together, you can see why both sides, content creators and users and free speech advocates, really don't like these aspects of the DMCA. Now, in the law's defense, it was enacted in 1998. We were all on modems. Nobody looked or even thought about some of these issues coming up because the volume of content out there, all these different copyright infringement strategies that are used to monetize content. None of that was around. In 1998, we were all on modems. Well, in 2019, 21 years later, this is the first year that Google's expecting to receive over 1 billion DMCA takedown notices. Think about that. In a year, they're going to receive over 1 billion takedown notices. So the volume that we're talking about now really is kind of moved beyond, I think, what anybody who wrote the DMCA was thinking about. And so the question now is, what do we do? The use of automated software could certainly, be attacked, I think, or certainly be limited. But then on the other side, how do we protect content creators? If you go out and particularly if you spend 3 months writing a book, and some jackass copies your book and starts selling it on Amazon, that's going to drive you nuts. So how do we deal with those types of situations? I don't really know, to be honest with you, and I've yet to hear a very good idea. In Europe, they've gone to a completely different system that they're going to try, called the Copyright Directive, and basically large volume sites are going to have to filter for copyrighted content. So if somebody tries to, post your course to, Facebook or Twitter or something of that sort, those companies are responsible for filtering it out. And that sounds great at first glance, but it doesn't really deal with the issue, because somebody who's copying your course, let's say, and going out and selling it elsewhere, they're not selling it on those sites. They're selling it on small pirate sites. And the Copyright Directive in the EU doesn't even touch those. And so it's, again, it's, completely kind of missed the point. The people in the EU, or the bureaucrats in the EU, are some of the most brainless people I've ever met in my life. But it doesn't address the issue. So do we need a change? Do we need an update? Yeah, we do. I mean, quite honestly. And I say this as somebody who runs a DMCA agent service and may be really hurt by any of these updates. Might kill our business. Who knows? But we've reached a point where it's kind of become a farce. If Google's receiving over 1 billion DMCA takedown notices in a year and views maybe 80% of them as nonsense, well, we've kind of reached a point where something needs to happen. So, anyways, what makes the DMCA controversial? Well, those are pretty much the reasons. Nobody really likes it that much at this point, but it's what we've got. And so until it changes, you kind of have to deal with these. So that's it for today's video. If you have any questions or comments, post them below. I'll do my best to answer them. Otherwise, have yourself a good one.